Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing requests for evidence, so-called RFEs, and the I-601 waiver process. A quick preface in this video: I've done a number of videos discussing recent changes to USCIS's policy regarding requests for evidence, specifically the rescission of what's called the no possibility doctrine, which basically used to dictate that an adjudicating officer at the United States Citizenship and Immigration Service needed to go ahead and issue an RFE, or request for evidence, unless there was, and I quote, no possibility that the case could be successful, that there could be an approval in the case. And that no possibility doctrine was a pretty tough one for those adjudicators to sort of, for lack of a better term, overcome. In most cases, they needed to issue an RFE if there was any sort of need for clarification, or even where eligibility had not been established, because it might still be possible for the case to be rectified pending further evidence being presented. That policy has been rescinded. It is no longer the policy of USCIS to issue RFEs sort of automatically where eligibility has not been established. The no possibility doctrine no longer exists. So what to take away from that from a practical standpoint, there's going to be, in my opinion, probably more denials of various petitions from USCIS as a result of a prima facie case for eligibility not being made. This could have a substantial impact on the I-601 waiver process. In the past, many of the cases I've dealt with in the context of the I-601 waiver have had an RFE component. They've had a request for evidence, most of the time something along lines of further clarification with respect to qualification of a relative, or further clarification with respect to how a given situation would result in an extreme hardship to an American citizen or lawful permanent resident, or lawful permanent resident. All of these things, sort of in total, sort of in the totality of the circumstances, resulted in a number of RFEs being issued. I think moving forward, the I-601 waiver process is going to get much more difficult. I think making one's case at the outset is extremely important. Notwithstanding that, we have in the past seen what I felt to be were pretty clear-cut cases go ahead and get an RFE anyway. And whether or not we're going to continue to see that, or it's just we're going to see faster approval, faster denial, that's hard to say. But what my gut tells me is all of this basically adds up to a larger possibility of faster denial rather than sort of faster approval. So the thing to take away from this is those who are serious about getting an I-601 waiver adjudicated successfully are strongly, strongly encouraged to contact a legal professional in order to get good advice regarding how best to proceed, and probably have that legal professional, if they've dealt with immigration matters substantially in the past, especially with respect to I-601 waivers, get that professional's assistance in order to get the best case on file possible in order to, if a denial comes down the pike, a motion to reopen, a motion to reconsider, an appeal even possibly. But again, all of that's going to be based on the initial filing. And where this no possibility doctrine has been rescinded, and it's now possible for a denial to just occur out of hand, it's possible, in fact, it's highly probable that weaker cases could sort of get locked in or sort of frozen as the adjudicative standard for what's going to be used on appeal, and that can be problematic. So the thing to take away from this, understand that this is something of a sea change with respect to USCIS doctrine, and possibly the assistance of a legal professional with respect to I-601 waiver filing is probably a good course of action, especially moving forward.